Good afternoon, everyone, and welcome to the ILI COVID series on what is whistleblowing and how can we protect whistleblowers. And right now, there's a lot of high-profile cases on whistleblowers. So we are really glad to have one of the premier experts to discuss the session with you. So I'd like to introduce Cheryl Goodman, and Cheryl is the president of Procurement Integrity Consulting Services. And I understand they've been so busy in the United States and all around the world. And Cheryl is a faculty at the International Law Institute, as well as the co-course advisor for the Procurement Integrity course. And she's also served as an Inspector General. So this talk is a part of the ILI's COVID series, and you can also find issues on whistleblowers in the ILI course on governance and anti-corruption methods in November, as well as the procurement integrity, prevention, investigating and prosecuting procurement fraud that will be delivered in October. So with this, I'd like to turn it over to Cheryl Goodman. Thank you.
Thank you so much, Kim and ILI, for this wonderful opportunity to present to you what and who is a whistleblower. It's been a joy to work with you all, and what a great series and some spectacular webinars you've had so far. So today we're going to go ahead and talk about exactly what is a whistleblower. What does it mean? Why consider the program? What types of laws and legislations are out there, both in the US and international environment? One of the topics that I found in East Africa is that there's some confusion between whistleblower and witness protection. We're going to talk about that. Key concepts for developing a law, reporting mechanisms. We're going to touch on the CARES Act and whistleblowers, and provide you all a summary after the fact. So what is a whistleblower? You know, many people look at it as twofold. One, as you see, the individual is kind of always doing the right thing, wants a good environment to work in, you know, really cares about what they do and what people do around them. And of course, then on the flip side, you have what people believe a whistleblower to be is that rat, that person who tattletales on people when they really don't want to hold people accountable. So that right there in itself begins that fear of, should I be a whistleblower? Should I not? What are people going to think of me? And it's a struggle. It's an absolute struggle. So what is an absolute whistleblower? Well, there's a lot of different definitions too of who actually is eligible to be a whistleblower. Is it an employee? Is it a contractor? Is it the general public? I've actually seen legislation that encompasses every single individual in their environment, not just a government employee, which is very traditional in most whistleblower laws. In this situation, really what you're looking for is the employee, or in many cases a contract employee, did they see a violation of a company rule or policy? Was there a violation of a law or a regulation, or was a threat to national security that led to fraud and corruption? Those are really key elements that you're looking for on why somebody would, quote, blow the whistle. And I always say there's a difference from a whistleblower and a blowing the whistle. Blowing the whistle means you have something to disclose, but it may not fall in the threshold of what justifies a whistleblower. For example, if a citizen saw a wrongdoing and wanted to report it, under certain laws, a public citizen is not considered a whistleblower. It would have to be an employee. So it really has to be well defined to be a, quote, whistleblower, as opposed to just, quote, doing a public disclosure, which is what many people call whistleblowing. To give you some examples, this was a very large, many people have probably heard of the Bernie Madoff. It was actually triggered by a whistleblower, this gentleman, Harry Markopoulos. He actually was one that reported in what was happening. And of course, this was in a time where we were reeling from the 2008-09 Great Recession, where so many people were losing their jobs, their homes, retirements. And you heard about a lot of the fueling of the misconduct on Wall Street. And this individual, Bernie Madoff, created a Ponzi scheme that resulted in really over $20 billion in losses to innocent investors that had, many, knew him so well, and they put their whole life savings to him, and it was all a scam, and it was incredibly unfortunate. And then in this situation, the Consumer Protection Act and the Commodity Exchange Act, these were all modeled after the False Claims Act and the 2006 IRS whistleblower rewards law. And it became very important because people began getting rewards, and you hear about the key TAM, and we're going to talk about that a little bit later. But the rewards were set out to be, you know, not less than 10%, but not more than 30%. And you can imagine on a $20 billion case, that's a pretty substantial payoff to this individual that actually reported this case. Another case in point is the whistleblower Bradley Birkenfield. And in this situation, this actually changed the course in the international banking by exposing illegal secret banking practices by the USB Swiss bank. And at that time, actually, the Swiss bank was the world's largest bank. And this was dealing with illegal offshore banking to evade taxes. And this particular whistleblower was a Swiss banker with insider information and actually came up with evidence of and beginning of a case where over 19,000 employees were known to not disclose secret amounts sent over to the Swiss banks and avoided taxes. So it was a pretty incredible case dealing firsthand with an international. Another situation in May of 19, another award of 4.5 million. You know, this was a case where the whistleblower was credited with the results of an internal investigation. So that was the first time we actually began to see internals become paid key TAM cases. And it really changed the dynamics of just waste, fraud, and abuse from an employee standpoint. These are individuals who are actually getting rewards. And there's this big debate about whether whistleblower programs should be set up with rewards. I've never personally been a fan of them from the employee side, because we always say you should do the right thing, and if you see a wrongdoing, you should report it. But the general public, obviously, if they're involved and they can involve themselves and have a key TAM, what they call it, to receive a reward for reporting, you know, that's a choice, I guess. But in the world that I lived in, we mainly dealt with government employees, and rewards were not necessarily the motivator. And this was the first time we actually had a foreign whistleblower. The Commodity Futures Trading Commission actually awarded over $70,000 to a whistleblower who helped in a particular investigation in their program. So more and more, again, we're starting to see major reward systems for people who blow the whistle. So what's a common government whistleblower? Whistleblower protection has two important areas. One, it's the confidentiality, and there's always, I always kind of challenge people when they say, oh, I blew the whistle, and I say, well, wait a minute, how do you shouldn't know who the person is who blew the whistle. Your name and identity should not be ever disclosed. But yet, if you're retaliated, you have to know who that person is. So it's kind of an interesting dynamic, and I'm going to talk a little bit about the state of Florida and how we actually have two parts of the law. One is to deal with the prevention side, where the person who's reporting does not get retaliated against versus the person who actually does. But a whole purpose to a common government, I call it a common government whistleblower, is to make sure you don't know who they are and to ensure that they are free from retaliation and they don't seek any kind of recourse for their job. And we're going to go a little bit specifically into retaliation a little bit later. So why whistleblower program? You know, this again is all about safeguarding the public interest, promoting accountability, and to really encourage waste, fraud, and abuse for being reported. You know, very, very important. Without whistleblowers, it's very difficult to actually find things out. We do find out a lot of things when people come forward to us and file complaints. But what's the challenge? I think we all know what the challenge is. You know, despite all of the efforts, you know, people have to make a decision. Are they willing to take the risk of being retaliated, losing their job, harming their reputation? It's a tough decision. And if you don't feel like you're in an environment where you're going to be safeguarded, then you probably are not going to see that person report. and internationally, we see a lot of cultural challenges as well, where in some ways, even though whistleblowing is all about protecting, the opposite is some see whistleblowers as unethical because they're going against their government and they're breaching things that they found out in the office. And in some legislation, it's actually, they could be held liable for taking information from the government and then blowing the whistle. So there's some real challenges out there as to the viewpoint of what is a whistleblower versus what isn't. Okay, so let's talk about, when we talk about the laws and institutional framework, there's a lot of different commonalities and there's a lot of differences between the whistleblower systems, both in the United States and also throughout the international environment. So let's talk about where the first whistleblower laws really entered in the United States, and it would be in 1778 when the Continental Congress passed this law during the American Revolutionary War. And they did it as a response to a 1777 case regarding 10 sailors. And this individual, this Commodore Hopkins, he was suspended and filed a criminal libel suit against 2 of the particular officers. And several whistleblowers reported back to Congress that they had been jailed and persecuted for what they felt was right in reporting him. And Congress actually threw their support behind these young officers and terminated Hopkins from the Navy and began, this was like kind of the beginning of enacting what we now know as the Whistleblower Protection Act. And then in 1779, Congress actually authorized the payment of $1,400 to cover their attorney fees. So even back then, we started to see some types of monetary return for that particular thing. So let's go to the next. After, of course, is our wonderful President Lincoln. And this was another situation where during the Civil War, Lincoln and his supporters in Congress were kind of disgusted with government contractors, some of which were selling sawdust as gunpowder and profiting from the really bad cost of the war. And congressional investigators uncovered the waste and squandering of the public funds. And back then, overcharging was very common, and war contracts were actually given without any advertising and, clearly exorbitant rates way above the market value. And so when Congress investigated the fraud, it was discovered that insider employees had blown the whistle and were subject to retaliation. So actually in 1863, President Lincoln signed into law, it was Bill 467, to prevent and punish frauds against the government. And today, we, of course, call that the False Claims Act, as it went through many, many reforms over time. Then in 1989, I think many of the viewers probably are familiar with the Whistleblower Protection Act. That was the beginning to kind of make things better for federal employees, although there were some really loopholes in that law as well, but the purpose was to really strengthen and improve the protections of federal employees, to prevent reprisal, and to help eliminate wrongdoing within the government. The law actually took several steps to strengthen those protections and clarify the process on how to report. But later on, we're going to see it wasn't quite where it needed to be. Part of that act was many individuals can go to the Office of Special Counsel, which exists to this day. But there are also some areas that they can't look into. So what I've come to appreciate in the federal government is there's well over 20 separate whistleblower laws, which I keep saying to myself, I want to combat that and be part of that solution. There was some talk of merging several of those laws into one, which I think would be a great idea. But basically, you have to go to the particular agency's whistleblower process to file a claim. And it can be very, very confusing when you don't know which, who, what, where, when. And in this situation, the Office of Special Counsel doesn't handle like claims for federal contractors or military members, so or even some of the intelligence communities. So it can get quite convoluted to the average person who's trying to do the right thing and report. and in return, they're not really sure who they're supposed to report to or which law applies, even though they're all called whistleblower laws. In part of the Whistleblower Protection Act, there are three options for what happens when you get retaliated. There's an affirmative defense appeal, there's individual right to action, and then there's a union grievance. And so the laws are pretty good when you've been retaliated, but I always say the whole purpose of making disclosures of waste, fraud, and abuse is to protect you from not knowing who you are, so you're never retaliated against. Other laws that have passed, there is the Sarbanes-Oxley Act of 2002. That came in response to the financial scandals involving publicly traded companies like the Enron Corporation, Tyco, WorldCom. I think many of you might be familiar with those. The high-profile frauds, really shook in the investor confidence and the trustworthiness in the corporate financial statements, and it led to a huge demand and overhaul of many of the decades-old regulatory standards. The act actually created really strict rules for accountants, auditors, and corporate officers, and imposed a whole lot of stringent record keeping. It also added new criminal penalties for violating security laws. And then subsequently in 2010, the Dodd-Frank Act also contained a provision that was entitled the Consumer Financial Protection within the Federal Reserve System, and that provided strong anti-retaliation provision models as well. So more and more we started to see stronger and stronger regulations and rules to protect whistleblowers. And in fact, in the Franklin Dodd, as you see on the slide deck, they actually provided a reward base in that situation. So that's where you start to see in 2010, again, the reward systems. Then in 2012, we had the Whistleblower Enhancement Act. And it was kind of an overhaul of the 1989 Protection Act, which was initially viewed as a really good law, but it actually had too many weaknesses to protect whistleblowers. So they moved forward with the Enhancement Act that closed a lot of the administrative loopholes and really helped whistleblowers come forward. And it clarified the scope, it created enhanced remedies. And part of that was to start to educate and train employees of their rights, and that to this day is required within a year. Every year they have to have, I believe it's every year in the federal government, training on what it is to be a whistleblower and what are their rights. An interesting thing too that was part of that law is the inspector generals were to designate a whistleblower ombudsman, and that stands to this day as well. Very important focus on being a whistleblower. Recent legislation, I actually just learned about this in my updating my presentation, that actually in 2018, Congress passed another Whistleblower Coordination Act, which permanently reauthorizes now they're calling it a coordinator rather than an ombudsman. And further, what's really kind of cool now is we're starting to see mediation now in these programs to kind of move cases quicker, is to get both parties at the table and try to resolve the retaliatory side of the house. And again, gets very confusing because the intent of a whistleblower program is to not know who the person is and never fear or face retaliation. But in situations where they're now incorporating this mediation program, and the Department of Defense was one of the very first ones that started this alternative dispute resolution. And it seems to be working very well. So I'm kind of going to be watching this and excited to see that maybe on the retaliatory side, there's a faster process for people to be made whole again and not go through a just arduous process and go years on end with no resolution. It's a painful situation. So taking a snapshot at the state law, there are 45 states and the District of Columbia that all have different varying whistleblower laws, and each has their own definitions, what is protected, but most are pretty consistent when you talk about violation of the law, performance of job duties, exercising their right when they have to testify, and reporting something in public benefit. They're all pretty similar in that circumstance. talk a little bit about the Florida IG Act. I'm most familiar with this being from Florida. In 1994, the IG Act actually was amended to create inspector generals. Before that, they were auditors. And as part of the inspector general role, legislation was passed under our ethics laws of Florida Statute 112, where we actually have a Whistleblower Act. And when I say it's, it's divided into two. The front end is the inspector general responsibility to prevent fraud, waste, and abuse. And the back end is when retaliation occurs, it goes to, in Florida, the Florida Commission of Human Relations. So it's a separate entity that deals with that. Why the IG keeps it confidential? You don't ever know who the whistleblower is unless their rights are waived and they don't mind their disclosure. But if they're retaliated, clearly you have to know who that person is, and so it's handed off to a Commission of Human Relations to handle that. Our clear laws it includes contractors. We had this big debate about subcontractors, but because we don't have a direct link to a subcontractor, by contract, we don't include subcontractors, just contractors that we have an actual direct link and contract where we could pull the contract. But ours focuses on the gross modifier. There's this now a shift. I'm seeing more and more international as well as nationwide that you're going to see the word gross in front of, gross waste or fraud, abuse, gross mismanagement, that the gross modifier applies. And why is that? Is because whistleblower cases are supposed to move very quickly, because you're dealing with people who are trying to save their, not be retaliated against their jobs, and they're supposed to be the most egregious types of cases, not your everyday cases that you do. So you're starting to see more and more the gross modifier is happening throughout many of the legislations. All of them are very consistent with the actions prohibited. You're not to discipline or dismiss, and I even take it further that, I used to teach my class and say, even if someone puts a negative comment in your file, that is an adverse action. You don't have to just suffer a consequence of, losing pay or losing your job or being written up. Even an oral and that's just kind of noted in a file can be an adverse action if somebody can see that file. So it's very clear that you just cannot do anything that's going to harm someone for reporting a disclosure under the law. And so here's another example of prohibited personnel practices. Again, we also see where employees that have been called into an IG investigation as a witness, they'll face retaliatory action for cooperating, and that again is prohibited as well. So it's an interesting dynamic that these kind of cases can take. I always tell management, if we're in on an investigation and it's a whistleblower investigation, it doesn't matter who it is. What we need to know is it true? Is it not true? Gather the facts and take no personnel action unless you have it clearly documented that it's a non-performer. And at times you will see there are employees that will try to become whistleblowers to saving their own job because they're not performing well on the job, and they'll either make something up or they'll tell something that's going on. But we always say if you're a non-performer, that doesn't give you the reason to have protection under the whistleblower law. So it's a tricky situation sometimes. But clearly, if they're not doing their job, then they don't get to save their job just because they reported something. But on the flip side, if they have reported something of a disclosure that falls in the definition of the law, then no retaliatory action should be taken whatsoever. And again, these are just more definitions for you all to keep, and on what prohibited personnel practices you traditionally find in many of the laws that exist today. So a quick look for my international folks that are attending the webinar today. I have spent the last couple of years in East Africa, and also went to Malaysia and Mexico and a few others. But this particular Nairobi workshop was for the East Africa area, and they call it the UNCAC through the United Nations. And basically through this workshop in 2017, there were 9 recommendations that came up surrounding the whistleblower and the witness protection program. And of course here you'll see the commingling of the two programs. But there were several goals. One was to have legislation to write policies and procedures, to raise the awareness of what these programs were, to have advice through legal sources, streamline the processes and around the country, and to build capacity. These were all parts of the goals for the East African contingency. And it's just to give you a little snapshot to kind of let you know what's going on in that world. Kenya actually right now has a draft whistleblower law. It's under consideration, but with COVID, actually, we kind of got halted here for a little bit. But they have the first law that I've seen where they actually define whistleblower and whistleblowing separately. And I think that's a great tool. So some of their legislation looks really, really good. We're working on cleaning it up, and hopefully in the near future, they're going to have their first whistleblower legislation. Ethiopia put one out very fast, and it was a combination, and really it's a witness protection law rather than a whistleblower law. It talks about life and limb. Uganda, their law is actually not too bad. It actually includes criminal and administrative. But it has a reward system in there, but there's no sense of how to get that reward. So it really sets everyone up for what I call unintended consequences that perhaps maybe they won't report when they realize they're not going to get an award because they have no system set up. So we're working with them on that. Tanzania, same thing. They have a witness and whistleblower kind of merged together, and they need to kind of separate that out. It's a little too commingled. As well. And then Burundi's just kind of in the very baby steps of talking about perhaps maybe they need a whistleblower law. So what I really learned from being out there was that there is some mass confusion between these two programs, whistleblower and witness protection. Of course, there is a huge difference between those two programs. Witness protection program, for those that don't know or not in the United States, this is really a government program that gives you new identities. It protects you so that you can testify in court. It may move your whole family. They may give you new residence, new jobs. It's a very expensive program, one that what I find in East Africa is they're not prepared to fund, and yet it exists on the books. So it's kind of again, kind of concerning that maybe it's not going to be successful because they just don't have the setup ready for it. And typically, of course, these are your criminal cases. The purpose of it, again, is really to, when you have to participate in as a witness, and to keep you free from life and limb and not lose your life for testifying. This is why people relocate you to a different part of the world sometimes, or another country, and give you all new identities. And these, of course, would be your very serious types of cases. It also encourages witnesses to come forward if they know that they'll have safe harbor. But again, it's a very expensive program, and one that has not been so successful out in other parts of the world. Separate from that, of course, as we've been talking about this whole webinar, is the whistleblower protection program, which is really about people exposing things that are deemed illegal or unethical, or just not right with respect to the job. So it's totally different, where whistleblower is about the job, witness protection is about life and limb. So, very, 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 very big difference when you're either going to lose your life or lose your job. So just some clarity for those that come from different parts of the world that are not familiar. These are two very distinct programs. And in situations for whistleblower, of course, they can be both administrative and criminal. So let's talk about some key concepts of developing a whistleblower law. So main components, we talk about this really about who does it apply to? Is it going to be an employee? Is it going to be a contractor? Is it a public citizen? The media, we even hear that out in some parts of the world. Who do you go to actually report this? There has to be specific people to report. What is the nature of the disclosure? What are you reporting? Does it fall in lines of what is a traditional whistleblower program? Do you have the option to report anonymously? Are there remedial measures if you are retaliated? Is there financial incentives? And of course, the awareness campaigns like we're doing now at the federal level, that everybody must be trained. So these are really, to break it all down in a very simple chart, these really are, in a nutshell, what are the main components to a whistleblower program. So we go through, who does it apply to? And there's a lot of different ways to do this. In the United States, we have prospective job applicants, current employees, former employees, certain contractors in our world. But two things. One, in certain legislations that are out there in the program, you do not need to request whistleblower status. It is the responsibility of the person taking in those complaints to determine whether it meets the definition of whistleblower. So very, very important to know that the person doesn't have to say, I'm requesting whistleblower status. It's really, in many cases, it's that if the person is disclosing to the right place, the type of nature, and they're qualified based on their status as an employee, what have you, then they can be deemed whistleblower without their requesting. An interesting thing, you know, where we have prospective job applicants, I never thought I'd see a case where I had one, but I actually did. I had a situation where I had a whistleblower in my agency, did the case. They were, you know, it was proven. And they wound up subsequently leaving to go get another job opportunity. And they were offered the position at another location in a different agency. And they called the manager, her supervisor, and asked for, you know, how she was and a background on her and how her job and how she was. And somehow, some way, that manager had figured out, even though we don't disclose, but had assumed that she was the whistleblower to that investigation. And she actually told the new hire agency that she was a whistleblower, not to hire her. She's nothing but trouble. So you can just imagine this woman won her suit in court. She was definitely retaliated against, lost a job offer that she actually was given. And it was incredible. I never thought I'd see it. So actually, job applicants can actually be victimized as whistleblowers. So employees protected, we talked a little bit about this earlier. You know, many of the statutes out there talk about who discloses, you know, information on their own initiative, if they're requested to participate in an investigation, if they refuse to participate in any adverse action. We've seen that where some, you know, a boss wants, you know, the next in line to take action on one of the employees that they supervise, and they refuse. Because they think, you know, that's the wrong thing to do. They all fit as a person who's protected. Anyone who files a complaint directly to their supervisor and the hotline or the inspector general, all those laws, any law you see will tell you who can you file your complaint to. In the federal government, it could be Congress, inspector general, the Office of Special Counsel. So your laws will tell you who must you go to in order to seek that protection. And again, what is protected? What is the protected disclosure? What in our situation, we see the word good faith actually in the international world in particular. They're starting to move away from that word of good faith. We sometimes use here in the United States the word reasonably believes, but you know, it's hard to make a judgment on whether somebody's acting in good faith or not. What really we should focus on is the allegation true or not? Is what they're reporting something significant that needs to be looked at too? And those disclosures are a violation of a law or a rule or regulation, you know, gross mismanagement, gross waste of funds, abuse of authority. And what I worked a lot of cases under is substantial and specific danger to the public health or safety. I came as an inspector general in one of the locations from the Department of Children and Family. We dealt with children not being seen and our elderly exploited a lot. And sadly, you know, we had many whistleblower cases that fell under the bullet of substantial and specific danger to the public health. Here's examples of where the to whom is to disclose to. And we just talked about the federal government has Congress, the IG's office. Some have an HR function. Always a supervisor is traditionally listed. Some have whistleblower hotlines or some other person designated. But the law will designate not only what should be reported, but to whom it should be reported. Very, very important. And again, the gross here for the nature we just talked about, the gross modifier, I'm starting to see more and more and more, and I think that's a good thing. You really do want to see that because these are supposed to be your most egregious cases. And so, of course, in your laws, you should have what defines an employee, what defines an independent contractor. Of course, it's usually with remuneration, which is money, wages. You'll see definitions of adverse personnel action, so people know what that means. You know, defining the gross mismanagement is important. I did when I was out in several locations internationally, I'd have them define management or mismanagement and then have them define gross mismanagement. And it was interesting to see the differences of the definitions. So clearly there has to be some consensus as to what these definitions mean so that you know whether or not you could have a whistleblower situation under the Protection Act. So, and of course, this is the old tort liability definition of gross. So again, gross, what could it mean? You know, everybody defines it a little bit differently. Some people say it's of significant importance, it's a serious error, it's more than a minor wrongdoing. But you can see where if you don't define it properly, you know, leaving it up to the judgment of however many people might touch that case or might have the opportunity to grant whistleblower, this becomes very tricky. You don't want to have too many people. I always say you don't want to do like the lawyer shopping. Well, if I can't get whistleblower protection over here in this agency, I'm going to go over here and try to get it from that person. So you have to be careful that these things are well defined. Again, another purpose of the Whistleblower Act is to not know who that person is to protect them from being retaliated against. And how do you do that? By not disclosing their name. You don't disclose their identity, meaning their position, you know, where they work. Writing these cases are very tricky at times because you have to really write it in a way that does not disclose the whistleblower. I kind of chuckled one time. They said, well, we'll have everybody testify but the whistleblower in the unit. And I go, well, then you're going to know who the whistleblower is. So you really have to make sure that you write these cases in a way that doesn't disclose who actually reported it. And I say it over and over and over again. It does not matter who brought this case to your attention. What matters is it true or not. That is the only thing that should matter, not who brought it to you. But interesting on and particularly in Florida, and we're talking about this international, is that a whistleblower can actually waive their protection, meaning their identity, if they want to. For example, many cases that start out administratively may turn criminal. Well, I've got to have a waiver in order to talk to the law enforcement or to the prosecutor, which 99% of the time the whistleblower will waive their right for me to talk to the prosecutor because they want criminal charges to be filed. So we have what we call a waiver process that the whistleblower can actually waive for me so that I'm not held responsible in committing a crime by releasing their name to certain parties that can help in the case. A lot of concerns that happen, of course, throughout the community is that the identity of the whistleblower, I mean, we see it constantly now that the identity of the whistleblowers are being deduced. People are figuring it out. And it's really becoming harder and harder for people to really want to come forward knowing that it's, you know, that their name could get out there. And so we really try to, you know, focus the attention again on, you know, what's being disclosed rather than who. But there's a big concern out there. We're seeing all kinds of whistleblowers, even in the United States, that are being named, or they're finding ways to name the person, and that's just not a good, totally goes against what this whole program is supposed to be about. Clearly, your whistleblower laws should have an ability to report anonymously. The hard part about that is if you don't know how to contact them, then it's going to be very difficult to get any further information. Some people set up a system where they give them a numbering system. So even though they don't have their name necessarily attached to it and they can't get whistleblower protection because they didn't give the name, at least we can get a number and communicate with them to find out further information to help run the case if need be. So there's different ways to go about that. But it's difficult to, if you don't know who the person is and they leave, you know, information like on a tip line, a hotline, and you have no idea how to get hold of them. You know, I always say looking for a needle in a haystack is very difficult to do, and a lot of times we lose, good cases, because it's just, we don't have the resources to chase that kind of thing. Penalties and remedies. Again, we talked about the remedies for this type of law. There has to be some penalties involved, and also remedies. Penalties for those who disclose the whistleblower, penalties for those who retaliate, and remedies for people that they have an avenue to go to when they feel like they've been retaliated against. Incentives, we kind of talked about that. There's a lot of discussion about incentives now as to whether or not you give them rewards for it. But I also talk about, if you're going to give a reward, then you're going to have to know who the whistleblower is, or you're going to have to set it up that you have a third party. And then do you trust that third party to make sure they give you the reward? So it's a little bit interesting dynamic on incentives, but many are doing it. And again, in the international world in particular, we're seeing more and more of this incentive coming about. And in this this particular, well, first in Article 32 and 33, for those that are in the international world, that's where this all comes under. And the United Nations had signed in with several nations, 140, to start to introduce the whole theory of giving rewards for combating corruption. They're trying so hard to do any type of aspect of combating corruption from any type of angle. They're so focused on it. And in some places it's working, and in some places, unfortunately, it's not. But this is definitely an attempt to start to have people report wrongdoing. Key TAMs, we talked briefly in the very beginning of the presentation. These are statutes that reward whistleblowers for reporting fraud, and they get a percentage of the government savings. They're very, very popular here in the United States. Other reward laws fall under the false claims, the state false claims as well as the federal. Tax fraud and underpayments, the Security Exchange Act, the Commodity Act, Foreign Corrupt Practices Act has it, which some of you all might be very familiar with, especially in my international community. And actually the Motor Vehicle Safety Act has rewards. And again, I kind of laugh because there's over 20 plus federal whistleblower laws, and only some of them have rewards, others do not. Here's some more: ocean pollution, the Lacey Act, endangered species, fish and wildlife, and financial institutions reform. So again, you've got to know which law to look at to see if you can get a reward based on what you're trying to allege is wrongdoing. Very interesting changes. The ACFE just reported out in their nation's report just recently. They just issued it about a week ago. And it was interesting because they took a survey, a global survey, where in cases where their reporting mechanism was used to report fraud, that now there's a substantial decline in the hotline over the past 2 reports, and they're going more to the email web-based, which in my world makes sense because we are so much on a computer today more than a hotline. And I like that actually, because you get more data when somebody writes you a complaint versus somebody calling in. So it's very interesting to see for the first time that the hotlines now are declining in their usage. The use of mail forms also dropped from 17 to 12%. These findings indicate that whistleblowers, again, are preferring the shift to the online electronic form. So that's all really good for efficiency, getting things, being able to communicate with that person on an email. So I'm kind of actually excited to see these stats go in the direction that they're going. But clearly, as we all know, the more avenues you have for people to report, the better that you might get those tips. Also in the Nation to Nations report, it was interesting to see that the top 3 parties that people are still reporting to is their direct supervisor. I found that very, very interesting. Just stunning to me that people are still feeling comfortable going through their direct supervisor and then to an investigative team or an audit team. So I thought that was very, very interesting data, that supervisors still seem to be where people want to go to get their help. And then in approximately 30% of the cases where the tip was made, the whistleblower did not use the formal reporting mechanism. So that's a lot of data there. That's a lot of stats for them to still go to their direct supervisor. So maybe that's a good thing. Maybe supervisors are handling it and things are getting resolved. And it's, maybe that's a good thing. I'm going to definitely keep an eye on that and see where that's headed, that they still feel so comfortable going to their supervisor in lieu of an IG office or somebody else. Also in that report, identifying how whistleblowers tend to report fraud to various parties can help organizations answer several questions. Who should be trained on how to handle that complaint? For example, those supervisors. How likely are whistleblowers to go outside that organization? And how should complaints lodged outside a formal reporting mechanism be recorded and escalated? So if it does go to a supervisor, do they know where it needs to go to make sure that it gets handled? So data is a wonderful thing, and the more data we know, the more we're able to answer these kind of questions and make this program even better than it is. So to whom did whistleblowers initially report? This was part of that data that came out in that report. And again, as you see, direct supervisors, 28%. I found that very, very interesting. And towards the bottom was the in-house counsel, which that doesn't surprise me. I always say in-house counsel is defending the agency, not the employee. So that's actually kind of good that they're recognizing that. But direct supervisor, and it seems to be the number one, and the fraud team, which is part of, I guess, the OIG, would be third and fourth. So very interesting data coming out this year that people are starting to just go right to their supervisors rather than outside the box. So more and more training probably needs to occur in that little box. So let's briefly talk about our COVID. Hope everybody is well and safe and did not fall prey to this flu, different type of flu, but if you did, I hope you're well. It was a scary event and it's still ongoing. Clearly, the United States is spending a lot of money, over $2 trillion in relief, because we did shut down for several weeks to months our businesses to keep our citizens safe against a virus that we didn't know where it was going to take us. So whistleblowers are going to be playing an incredibly vital role as we uncover abuses in both the healthcare industry, airline industry, the small business industry, the elder care. There's going to be, unfortunately, because this was rolled out so quickly, I think we're going to see a lot, and we already are seeing, fraud occur, combined with just, because it was rolled out so quickly, policies and practices weren't in place. And so there's going to be errors made unintentionally in giving out money that is to no fault of anybody's. It's just, it was an effort to get money out very quickly to try to save our local businesses, but in return, the government wasn't prepared to let all that money go without proper guidance in place. So we're going to see more and more of this confusion roll out. And what I think the most challenging is going to be what will be considered a fraudulent act versus a mistake, an unintentional mistake. So for the CARES Act, what laws cover it for whistleblowers, it's going to depend on where you work, what state or country you reside in, and what you're actually reporting. Are employees who report health and safety violations protected under this law? Yes, however, there's no general federal law covering the health of whistleblowers, but instead there's a patchwork, as we talked about earlier. So you have to really know which law it will fit under, whether it's actually protected or not. Private sector employees can primarily find coverage under the False Claims Act. Of course, we also have the Whistleblower Protection Act and the Enhancement Act as well. In the securities, we talked about that earlier, the U.S. Securities Exchange would be one that some may go to in the commodities and trading environment as this pandemic, continues and people start doing the grants and investments of loans and things as well. Treasury will be a big piece of that. What laws are covered? Again, the key TAM may actually, under the False Claims Act, be considered. during this whole process. If there's, a lot of money going out the door, this may be another act that may actually, whistleblowers may fall under, and report things that they see in the future. We don't know what's going to happen. We do know there's a lot of money, and where there's a lot of money, unfortunately, there's going to be people taking advantage of it. So in summary, to design an effective whistleblower program, really it's about identifying wrongdoing, mainly in the, whether it be the government sector or the private sector, for employees to know who to go to, what to report, the old who, what, where, when, how, why, what is it that you want to disclose? Does it fit the definition? Do you go to the right person? And what, do you even fit as a definition? A lot of times, like I said, talked about earlier, some countries actually have the public as a whistleblower, but that really doesn't fit, because a public citizen doesn't work for the government. They can't get retaliated because they can't lose a job they didn't have. So again, it's, are you eligible, nature of the information you're disclosing, and who are you going to? Very, very important in designing this program. And again, just another chart to kind of go over it one more time. The types of issues, the specific channels, timeframes. Timeframes are very important under this kind of environment. You just can't let cases go on for years on end. In Florida, cases have to be done actually in 60 days, unless there's an exception. So cases have to be moved very, very quickly. So the good, clearly a good whistleblower program is very integral to any environment to foster transparency and promote integrity, and really to weed out waste, fraud, and abuse. It really is the ultimate line of defense to safeguarding the public interest. Wonderful program to have when it's working well. The not so good is it's a tough decision, especially if your organization doesn't want to hear the truth, is not interested in compliance, and you could be, subject to retaliation if you don't have strong processes in place to ensure that doesn't happen. So there are a lot of challenges there to a real good program, and we're seeing it here even in the United States. So again, two types of whistleblowers that we see today. In these programs, there's the employee that wants to hold people accountable and do the right thing, and now we're seeing these rewards systems where you actually can receive a percentage for reporting bad behavior or fraud, waste, and abuse, even from the private sector environment. And always know, this is, I always like to close with this, a wrongdoer doesn't go unnoticed. Many staff and people who work with that person know there's something wrong. It's very critical for the organization to have that environment where people feel to report, because you think about somebody that you work with and you wonder and go, is that person really doing the right thing, or are they taking things out of the office, or what have you? But many times these subjects of investigations are not unnoticed. People know. It's whether or not they're willing to report it or not. So with that, I'd like to thank everyone for listening to this webinar. I hope you learned something from it, and I'm going to turn this over to Kim to close us out.
Thank you, Cheryl. That was a wonderful presentation, and I can see why you are so busy these days. And thank you for giving us the background, the history, the legislation, and also the updated research and how it relates to COVID. That was an outstanding presentation, and thank you for your time.
Absolutely, it's my pleasure.